On Monday the 14th of May 2018, after a 3-day trial, Southwark Crown Court sentenced Jeremy Bedford-Turner, known as Jez Turner to attendees of the London Forum, to 12 months imprisonment, 6 in custody and 6 to be served under licence. The charge was conduct intended to stir up racial hatred, and the case raises serious concerns about freedom of speech in Britain and the actions of our judiciary. Mr. Turner spent 12 years in the British Army, left with an exemplary record, and has a knowledge of Pashtun and Arabic. During his army service, he was involved in transcribing the identifying features found on many terrorist explosive devices. The alleged offence took place in 2015 during an organised protest in Whitehall against the Jewish Shomrim, a type of private police force or vigilante group formed for the protection of London's Jewish residents. The Shomrim use cars that look like police vehicles, and its volunteers dress like uniformed police officers. It's thought that it is largely funded by taxpayers and yet serves the interests of its own particular ethnic group. This legitimate demonstration asked the question why no other racially exclusive group is allowed to form its own private protection force and behave like an official branch of the police. Initially, the CPS, or Crown Prosecution Service, said the evidence fell short of the standard required for a prosecution, but the persistent actions of a charity calling itself the CAA, or Campaign Against Antisemitism, threatened a judicial review and thus badgered the CPS into reconsidering its decision. It is precisely this disproportionate amount of Jewish influence that is the crux of the argument against the Shomrim and the reason behind the protest. Mr. Turner has been the driving force behind the London Forum for many years, drawing nationalist speakers from across the world. He initiated the Scottish, Welsh, South West and Yorkshire forums. He was interviewed on day 1 of his trial on May the 10th.
We're outside Southwark Crown Court today with Patriot Jez Turner. He's in court for a freedom of speech issue with the religion that cannot be criticised. Are we even allowed to say?
They steal and they pinch. New shoes.
Are we even allowed to say the word Jew now?
It's getting to the stage where you cannot say the word Jew. In court they prefer to say Jewish people. But for this video we'll use the word Jew. It's a lot less silly.
Yeah, the oppression, do you feel this Jewish oppression?
Sort of a police state almost. We're getting there now. We have something called Prevent, which is like secret police. They question people for extremism, but only when it's extremism against Jewish interests or the Jewish agenda, liberal agenda. Right. So they don't question Hindu extremists, Sikh extremists, environmentalist extremists, animal extremists, etc. They just question Islamist extremists and so-called far-right extremists.
Well, they're not the chosen people, are they? Okay, for the benefit of our viewers, could you tell, in your own words, say exactly what you wanted to say about this case?
Well, I'm here today because I questioned Jewish power. I criticised Jewish power. I criticised something called the Shomrim, which is a uniformed vigilante police force in North London run by the Jewish community. Government funded, they get police cars that look like police cars, they get uniforms, they get police weapons, arms training. And
what's wrong with that?
Well, what's wrong with that? Let's all have vigilante forces, let's all have them, but for all ethnic groups.
Well, what's wrong with criticising that then?
Well, the thing about Jewish powers is if you criticise Jewish power, Jewish privilege, they use the Jewish power, Jewish privilege to put you in court. Now, there is no disgrace in being wrongly convicted. Princes, prelates, popes have all been in the dock, as have bishops, and even barristers have been in the dock, wrongly convicted. And there's no disgrace in being wrongly convicted of a crime that never used to be a crime. It shouldn't really be a crime. English common law has always had a clause that rules out incitement to violence. That's always there. Now, these new laws they brought in are quite unnecessary, right? These new laws are supposedly designed to prevent incitement to violence, so they say, right? These race laws, these hate laws. But what they really are is against free speech. That's pure and simple what they are. They're just laws against free speech. They're grey, they're vague, they can implement them when they feel like it. against who they feel like implementing them, and they can ignore them in other cases, and designedly so, because that means they can enforce these laws selectively. There is no fairness with these laws. There's no parity. There is no equality with these laws. For instance, an Asian female student at Imperial College tweeted, "Kill all white men." Now she wasn't prosecuted. She wasn't sent to prison. She wasn't fined. No criminal record. She didn't even lose her job. She wasn't even thrown out of university. Right? So this goes to show these laws are not enforced equally. They're not enforced against non-whites. They're not enforced against those who we cannot mention. They're not enforced against Jewish people. The entire purpose of these laws is to stifle legitimate political discourse and debate. They are not designed to protect whites as an ethnic group. In fact, they're designed to prevent whites protecting themselves as a group. The laws in themselves, in essence, discriminate against white people. The very laws encourage hatred and discrimination against white people.
So, okay, as regards your court case, Jez, did you find it quite worrying that you had to face up in English law, knowing the sensitiveness of this case and how overrepresented the Jewish community is in our legal system? I mean, how did you feel about that? Because that's the irony, isn't it? They prosecute you, and he wasn't prosecuted by the
situation
CPS, was you?
The police
wasn't it a Jewish organisation?
The police thought there was no crime, right? The Jews put pressure on the police and the Crown Prosecution Service and the government still thought there was no crime. So the Jews put more pressure on there, and a group, a Jewish charitable group that engages in political witch hunts, put pressure on the government. They brought a judicial review, okay? This is a private prosecution. The government caved in, and now here I am today. So it was all about a speech 3 years ago, 4th of July in Whitehall, where I gave a speech against the Shomrim. I said, why is it the Jews have their own vigilante force? Why is it that? I said it's because of Jewish power, Jewish privilege.
If they've got their own police force and you criticise that, and you're obviously now being charged with that free speech abuse, if the next step was that they felt so threatened that they wanted to carry firearms, I mean, they'd get that, wouldn't they? Because who would stand up against it? You know,
Exactly.
They don't carry firearms for their personal protection.
No one dare criticise them. Oh yeah, so the lady is telling me that our tax-paying funds go to help the Shomrim.
Yeah, there's a huge public audience here who want to back you.
There's nobody on the mainstream who dare criticise this thing. It only had one article in an independent magazine, independent newspaper, and that disappeared overnight. So,
yeah, because we know who controls the news, don't we? I mean,
yeah, I mean, look, you've got the Shomrim as a uniformed Jewish police, and then you've got the CST, the CAA, Hope Not Hate. These are like the non-uniformed police, investigative, CIA, what do you want to call them, CID, whatever.
Shabbos Goys.
Whatever, they go around hunting us down and this sort of thing. And they want to close down free speech. Now my chances, as you say, I'm in a system where even the judge will be scared of the Jews, just like Cicero, he'll be whispering, you know. My chances are slim, but I have a jury. And if you have a jury, you have a chance. But we see the effects of the liberal agenda all around us in London. Carry on. With a quote here by a previous ruling by Lord Justice Sedley, very apt for the purposes. Free speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, providing it does not provoke violence. Freedom only to speak inoffensively is not worth the having. Thank you very much.
Some claim that two statements in the Shomrim speech are disputatious, but the vast bulk of comments were factually correct. The speech was forceful but articulate, well spoken, not threatening, insulting, nor intended to incite. The court case rested on the testimony of one single police officer. Of all the dozens of police officers on duty, not one claimed that Mr. Turner should be arrested and charged with any offence. Only the CAA did this. The CAA claims to be a charity and includes this recent self-congratulatory statement on their website. The CAA was represented pro bono, i.e. in the public interest, by the leading counsel Brian Kennelly QC and solicitor David Son, to whom we are immensely grateful and without whom Mr. Bedford-Turner would have escaped justice. The charity claims impoverished status and that it relies on volunteer legal services, but this claim is disingenuous. The defence asserted that the CAA is actually very well represented legally and can call on expert legal backing if it needs to. The CAA also openly boasts about its close connections with government departments, so for a charity claiming limited means, it certainly has far-reaching influence. How many other so-called charities can lobby government departments and push the CPS into prosecuting individuals it disapproves of? Here's Mr. Gideon Falter of the CAA boasting about his close working relationship with Downing Street.
And we work very closely with the Home Office, we work very closely with Downing Street. So, we work very closely with the Home Office, we work very closely with Downing Street.
And here he is again explaining that he has decided a crime has been committed and that the CPS have got it wrong and why his decision is much more important than anyone else's.
The police who were surrounding him when he made the speech outnumbered him about 15 to 1. They failed to make an arrest. Not only that, but they also failed to clock that a crime was taking place in front of them until we reported it.
And here he states that he was present at this Shomrim protest, a claim he later retracted. He was not there at all, and therefore could not truthfully claim to be a victim. Clearly, his memory had failed him.
We're constantly being contacted. In this case, it was unusual because I was actually there. I was actually the victim, and I was able...
Which is why the CAA's whole case had to rely on the testimony of one single police officer. It could be argued that the CAA's use of the hate crime label is actually something of a deception, and that their real motive is to silence criticism. There have been many recent instances of hate crime prosecutions resulting in current or proposed jail sentences. It can also be argued that jurors are intimidated into giving guilty verdicts for hate crimes because peer pressure means that nobody wants to appear to have a racist viewpoint. A secret ballot for jurors would eliminate this risk. Incitement to racial hatred is a subjective view and relies on opinion rather than established fact. Veteran political activist and journalist Michael Walsh writes on his Europa website, "Just as a football team is controlled by their manager, so is a jury. The state's prosecuting counsel, aided by the state-sponsored judge, is adept at creating a courtroom atmosphere hostile to the defendant. The judge controls questions posed by the defendant's defense and constantly interrupts protests by the unfortunate victim in the dock or his defense counsel. I told Jez that the sentence before the trial had already been agreed upon and passed by unseen men in the background. The court appearance is theatre to give a false but reassuring semblance of justice being met. The inexperienced jury are putty in the hands of professional jurists." A journalist who attended the trial says that the judge and prosecuting counsel were enforcing the politically correct view of the world. This, of course, is far removed from all reasonable concept of justice. During the court case, there was not even a nod at the notion of freedom of speech guaranteed as a human right. The UN Declaration of Human Rights states that everyone has the right to freedom of opinion and expression. This right includes the right to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. The writer goes on to say, "What has been made very clear in this trial and that of the trial of Alison Shablow is that we have an elite which is hell-bent on squeezing the range of permitted opinion ever more tightly into a politically correct shape. Corporate-owned media, itself as controlled as the electoral and judicial process, cheered the verdict and acted as the public prosecutor by giving a one-sided account of the trial and verdict. Yet the irony is that by caving in to a British-based, foreign-funded Zionist omnipotent cabal, the jury, prosecuting counsel, Metropolitan Police and corporate media found Jez Turner not guilty but proven right, that Britain is indeed ruled by Zionist influence." Because of hate crime laws, an individual of good character has had his freedom taken away, his reputation smeared, and his life damaged. We must ask the question, who is it that is doing the hating here? Is it people like Jeremy Bedford-Turner? Or is it a vindictive, racially exclusive minority intolerant of criticism that uses its pervasive influence to prosecute anyone who dares expose their hypocrisy? Interestingly, the mainstream media, also known as the controlled media, did not give great prominence to Mr. Turner's case. Could it be that the instigators don't wish to publicise their efforts to silence critics too widely?